All right. Well, it's an honor to be here. As Ms. Highland said, my name is Ray Hacke. I'm an attorney with the Pacific Justice Institute. This June, we will have been in Oregon or had an office here in the Salem area for 4 years. I moved up here in June 2018 after becoming an American or after becoming a member of the Oregon State Bar back in 2017. We've fought and we've are currently fighting a number of different battles on the religious liberty front and the parental rights front. Some of it's involved sex ed. In fact, if it go back to my time in the San Francisco Bay Area, I actually convinced the Cupertino Union School District to not adopt, or at least hold off on adopting, a certain sex ed curriculum there. I've also, gone before the board, the school board in Hillsborough, and battled them there. I'm also the husband of a teacher in Salem Academy. I'm so glad that my wife works in that private school because, well, my daughter gets to go there for free, and I don't want her in the public schools if I can avoid it. I'm also the son of a teacher in the Dayton School District who used to work in Newburgh. And I'm real familiar with what's going on there. In fact, I just hired a legal assistant who worked in the Newburgh School District. The thing is, I would say they're on the right side of the law because teachers do not have an absolute right to political speech in the classroom. I mean, they don't check their First Amendment rights at the schoolhouse gate, but in light of the special characteristics of the school environment, their rights are limited. But I will get to that. So basically what I want to talk to you guys about today is viable legal actions in today's climate. In order for me to do that, I need to discuss what your rights are, both your children's rights. I mean they're the reason why we're here. As well as your own rights as a parent. First and foremost, I do want to make clear though. I want to be real with you about the legal realities that we're facing. Going to court and filing a lawsuit is not always the best or wisest course of action. Courts give school boards very, very broad discretion as to in terms of the management of their schools and the curriculum they adopt and that sort of thing. Courts are not likely to strike down a school board policy or a decision unless it clearly contravenes basic constitutional values. But that said, as parents, we need not throw our hands in the air and just give up and accept that public schools are, irredeemable, and using our tax dollars to indoctrinate our kids. You still have some power to affect change. So first and foremost, when it comes to your children's rights, there's a case on the books called Tinker v. Des Moines Independent School Education. This was a case that was decided a little over 50 years ago, back during the Vietnam War. It involved some kids in Iowa who wore armbands to school to protest the Vietnam War, and they got in trouble for it. Now, the key line from that case, and it's an important one, it said, it can hardly be argued that either students or teachers shed their constitutional right to freedom of speech or expression at the schoolhouse gate. In other words, if your child wants to talk about Jesus to his classmates, as long as it's not during class time, they can. If they want to pray, before lunch, or if they want to read their Bible during their lunch hour, they can. If an athlete wants to kneel down in prayer, before taking the court or the field, they can. If they want to wear a T-shirt displaying a Christian message, they can. Whether it's a cross, whether it's a reference to a Bible verse, whatever else. If they want to sing a song, like a Christian song, including a Christian song during a talent show or assembly, they can. It's their choice. If they want to write about a hero, and basically somebody, if their class assignment is like, who's your hero? If they want to write about Jesus himself, they want to write about Donald Trump, they can. The only thing they can't do is cause a substantial disruption. Okay, so in other words, they can't, interrupt the teacher during class. They can't, try to hijack an assembly. They can't, the fact that it might make some people uncomfortable or triggered is the popular word. That's not good enough. Okay, now the next case I'd like to talk about is called Rosenberger and Rector v. Rector and Visitors of the University of Virginia. Now this is a case that came about in the university setting, but it still has some applicability to public schools because it comes up with the topic of viewpoint discrimination, and so this is especially relevant if they're having like an LGBT related discussion in the classroom. Now I should mention that within the past couple of months, I think somewhere around October or November, I had a parent reach out to me from, I believe it was either Gresham or Sandy, somewhere up there, and their student had to read a book by a very prominent gay writer, and this book, really, slandered Christians, and basically it flat out said, that God needs to be done away with, and this student literally felt under attack in his classroom whenever they discussed it, and he felt like, well, I want to be a loving person. I want to be I try to be a good example of what a Christian should be. But yet, here I am, being unfairly stereotyped. Okay, and if this was a Muslim student, there's no way the school would attempt that. And so I wrote a friendly little letter to the school saying, kind of reminding them about this little statute you might know of called ORS 659.850. That's Oregon's discrimination in education law. Which basically says you cannot discriminate on the basis of religion, okay? And I would argue that also applies in the context of CRT, which we could get to in a moment. But bottom line is they backed down. The kid got an alternate assignment, and because, well, let's just say school districts don't like to be sued, so threats of legal action can be quite effective. So anyway, one of the things, I do need to mention is the Equal Protection Clause of the U.S. Constitution. Now, basically when it comes to the Equal Protection Clause, that means that Christian students and students of other religions, as well as LGBT students, they have equal rights in the classroom. They're entitled to equal protection. Now, I'm not suggesting by any stretch of the imagination that LGBT kids deserve to be bullied or trashed or or that schools shouldn't take action to prevent them from committing suicide, because that is a problem. They're entitled to kindness and compassion and being treated with dignity and respect like anybody else. They're human beings, absolutely. Okay, but at the same time, we can't just say we can't go to the extreme of trying to protect them and trying to vilify another group. Okay, and so that's so anyway, that's especially true given the Supreme Court's words in Obergefell v. Hodges. Some of you may be familiar with that case. That's the one that made same-sex marriage legal nationwide. And one of the things that they say in that case is that many people who believe same-sex marriage to be wrong do so based on decent and honorable religious and philosophical premises. So in other words, people who hold that viewpoint aren't necessarily bigots. There aren't necessarily homophobes or transphobes or whatever else. They're not hateful people. Okay, the highest court in the land recognizes that there are some decent people who may disagree with that lifestyle. Okay, and if your student is one of them, and then they have the right to express that, and they have the right to not be attacked for sharing that viewpoint. They may have people who vehemently disagree. But that's the whole point. If schools are kind of like the cauldrons of public debate, if that's what they're preparing, if they're preparing students to be informed citizens, then yes, they need to have opposing and controversial viewpoints expressed. So now another case is the Master v. Skate Shop versus Colorado Civil Rights Commission. Now this one you've probably also heard of. This is the case involving the baker in Colorado who refused to bake cakes celebrating same-sex marriage. And again, it's not this is not a school case per se, but it certainly has applicability within the walls of public schools. And so basically the Supreme Court wrote there, quoting Obergefell v. Hodges, which I just talked about, that the government, if it is to request the Constitution, if it is to respect the Constitution's guarantee of free exercise of religion, cannot impose regulations that are hostile to the beliefs of affected citizens and cannot act in a manner that passes judgment upon or presupposes the illegitimacy of religious beliefs and practices. In other words, school districts and classroom teachers must be very careful not to condemn certain religious beliefs or viewpoints because they conflict with, with what they're trying to teach. Okay, that would violate the Establishment Clause. That would be showing hostility toward religion, and the Constitution. And I should mention not just the federal Constitution, but the Constitution state of Oregon prohibits that. If you look at Article 1, Section 20, Article 1 of the Oregon Constitution, which is basically Oregon's Bill of Rights. Sections 2 and 3, specifically concern freedom of religion. Section 2 specifically concerns, being secure in the right to worship God according to the dictates of one's conscience. And Article 1, Section 20 concerns the right to, it's what's called the Oregon's Privileges and Immunities Clause. So no privilege or immunity shall be given to one group that isn't granted to another. And so basically it's like, we can't try and protect one group and leave the other one vulnerable. So anyway, I remember when I testified before the Hillsborough School District, a school district official said that he pulled a particular portion of their curriculum because, it kind of demonized, it showed, kind of a judgmental Catholic mother. It said, that was an unfair stereotype, and that was the right call on the district's part. So sometimes they do get it right. But, now moving on to your rights as a parent, I'd like to start with a case that originated right here in Oregon. It's called Pierce v. Society of Sisters. In this case, Oregon tried to force parents to send their kids to public schools for education. Well, the Supreme Court said, nope, if they want to homeschool their kids, that's their right. If they want to send their kids to a place where they receive religious instruction in addition to math, science, history, whatever else, they can do that. So essentially the Supreme Court recognized that parents, they do have, they're the ones who are ultimately in charge of their children's education, okay? And I think, certain teachers and, well, especially their unions seem to have forgotten that. They're so big on trying to undo what certain parents are teaching their kids and basically kind of teach them the way they think they should. They've forgotten their place. And so, now, I need to be clear that the Ninth Circuit, which is one level below the Supreme Court and, whose decisions are binding on Oregon, they have said that school districts, they need not bow down to parents all the time, especially when they oppose a particular curriculum just because they find it offensive. However, that said, Section 336.465, subsection 1A of the Oregon Revised Statutes declares that you do have the right to review a class's curriculum and materials and discuss them with the teacher, regardless of the subject taught. So, it could be math, it could be history, it can be, whatever else. And so if you find something objectionable, you can go to the teacher and you can basically say, hey, this is a problem. What can we do about this? Whether it's giving your child an extra assignment or whether basically holding the teacher accountable, saying, okay, if they're going to show that, for instance, Christians were, there were Christian slave owners or slave owners who claimed to be Christian. They also need to teach that Christians were at the head of the abolitionist movement. Absolutely. Be fair, be equal, hold them accountable for it. I'd also like to point out that as I said earlier, that a teacher's First Amendment right of free speech is not absolute in the classroom given its special characteristics. I've had people as far north as Oregon and as far as Oregon City and as far south as Ashland contact me about, the fact that they see BLM posters on the wall in the classroom. I even had parents, One parent, was a police officer, and basically their kids felt under attack because the police were getting bashed. Unfortunately, being the child of a police officer is not a protected class, but still. So a court would probably to some degree uphold those actions, only because it depends on why they're there. I know a lot of teachers are asserting that, saying they have the BLM poster or the BLM flag or the pride flag because they want people of color and LGBT students to feel welcome in their classroom. Well, what about people who don't fall into those categories? They need to worry about them as well. Students are not yet possessed of the capacity to make informed decisions. The law still recognizes this, even if it's not to the extent that it should. There's a great deal to guard against with regard to political bias in the classroom, when a teacher speaks in the classroom, he or she is speaking on behalf of the government, the state of Oregon, and their speech must comport with the school's educational mission. On top of that, schools are not indoctrination centers, or at least they're not supposed to be. And it's precisely because teachers are in a position to influence young minds. In fact, that's why many of them took the job, that they not only, that you have the right, if not the duty, to remind, to remind, recognize how your teacher is influencing your child, and so you kind of need to be able to take control that way. On another note I'd like to address your child's right to medical treatment. Now, if your child is 15 or older, basically they have the right to make medical decisions for themselves. I don't agree with it. I don't like it any more than you do, but that is the law. So let's just be clear that the law is not necessarily a basis for morality, there are a number of things that are not right about the law. So this means that if your child wants to get an abortion, or if they want to go get, undergo transgender transitioning surgery, or get tested for STDs or something like that, they can. Studies show that the child's that light is really bright. Studies show that children's brains aren't fully formed until they're 25 or so, which means they could potentially be making a mistake that could have lifelong consequences, and you're powerless to prevent it. You're the one who's, and sadly, I hate to say it, but if they're on your insurance, you're the one who's going to get stuck with the bill. So now, Oregon law does not give minors a right to confidentiality, okay, nor does it give parents a right to disclosure. So here's what that means. If your child goes to the school nurse and basically says, I'm thinking of transitioning, or, I think I might be pregnant, then basically the nurse doesn't have to tell you about it, but, the fact of the matter is, if you have a good school nurse and said, that nurse can reach out to you and say, hey, your child's in trouble. You may want to talk to him or her, and you can certainly appeal to the nurse and say, I need to help my child. Can you tell me anything? You can appeal to their conscience, and hopefully you can persuade them. However, Oregon law also and that's huge, okay, because it explicitly recognizes that parents can and do provide much needed support when it comes to their children's medical care. Now, here's the good news. If the school lets the child leave campus, if the school nurse decides to take your daughter to Planned Parenthood, and something happens on the operating table, then the school's liable. Okay, because the student has a duty of care and supervision of your child. Okay, and so that means that if somebody affiliated with the school district, writing in his or acting in his or her capacity as a district employee, takes the child off campus and something bad happens, the school will open itself up to a world of liability. Because the school, when your child's on that campus, they assume liability for the student's safety. So now, knowing that you're right, knowing your rights, here's some viable legal actions you can take. Now, first of all, I want to be clear, litigation is an absolute last resort. It's an uphill battle. It's expensive, it's stressful, it's time consuming, and there's no guarantee of a desired result. It can take years. Given the broad discretion that that courts afford to public schools, it's a battle that you're not likely to win unless you can show that a teacher, school, or district is discriminating against you or your child in some way, or B, either your child's rights and constitutional rights, or child's constitutional rights, or yours are being violated. Now, if you pursue litigation, either you and your child are going to they're going to need some courage to do it, because especially since Oregon has a lot of small towns. Word gets out, and people experience backlash. There's an uproar. I've got 2 teachers in Grants Pass that I'm representing right now who are they're actually on your side. They're actually trying to. They feel like, like if a student comes out to them as being, LGBT, they feel like they should be able to talk to the parents and, kind of bring them involved in the school, and the district is telling them, no, you have to keep that a secret. And they got fired over it. Now they got reinstated in November, but, they're, but still, they're kind of, they're kind of on thin ice with the district right now, and come March, there's no guarantee that they'll be offered their jobs, be offered a new contract. Your best bet, if you want to sometimes a lawsuit, will hit the papers and people get calls and get calls from angry neighbors, and there's no point in pursuing it if you're not willing to see it through. Okay, you've got to have the steel resolve to be able to push for it. You've got to be absolutely convinced of the rightness of your case, and you've got to be unwilling to swerve to the right or to the left. If people start pressuring you, if they start bad-mouthing you, whatever. So you need to have a steel spine. Your best bet is to try and bring about change legislatively. So write or call your. First of all, you've got. You need to vote for state legislative and executive positions. Who are on your side and who you believe that will enact change. Or not try to advance a left-wing agenda. You can write or call them. Because that's your right. That's the beauty of this country. You can petition your government for a redress of grievances. Pay attention to education bills in the legislature, and you can testify for or against them. And the beauty of that is you don't even need to go to Salem to do that. Because of COVID, most of it's been handled by video conferencing. So you can do it from the comfort of your own home. At the local level, this means supporting school board candidates along the same lines, or even running for the school board yourself if you feel so led. I mean, if that's just your conviction, if you feel that strongly, go for it. Okay, so you can use your influence. So if you run and you get elected, you can use your influence on the board to determine what textbooks and what curricula are used. And if you're not inclined to run, show up at meetings. Literally be a thorn in their side. Okay, I don't mean that. Be a pain in their neck. I mean, absolutely. Because when they open public commentary, preach the same message each time. Okay, I don't know if any of you have ever seen the movie The Shawshank Redemption. With Tim Robinson's character. It takes place inside a prison. So he wants to get a library built inside the prison. So what does he do? He writes a letter to the legislature every single week. And so they say, finally they decide to get him to try and get him to go away. They say, here's $500. We consider the matter closed. And he's like, great. I'm going to write 2 letters a week. Be like that. You can also reach out to other parents and other concerned citizens whose tax dollars are funding this stuff in the schools, and you can get them to do the same. Because if you keep showing up, you may just wear them down. Just keep at it. You can also attempt to influence what's being taught at your child's school by serving on on a 21st Century School Site Council. And one thing I forgot to mention, which is kind of important, when it comes to sex ed classes, you can opt your child out. So, you have that right. So ultimately, you just heard me quote The Shawshank Redemption. I'm a movie buff, so I'm going to leave you with a line from from one of my favorite movies. It's called Mr. Smith Goes to Washington, old 1939 film starring Jimmy Stewart. It's kind of become a personal mantra for me. You fight for the lost causes harder than you do for any others. So I encourage you to treat, the fight for parental rights in public schools as a lost cause and fight for it harder than you would for anything else.